Yes, Sister Gibson.
Ladies, my lords, just before I return to my submissions, we have sent electronically the updated MS reference document. Mitigate to some extent the length of the documents.
And it's embarrassing to ask. A hard copy for me?
Yes, that will be made available at the end of the day.
Thank you.
Do we have the supplementary volumes in electronic form? They're listed on the master index, but I'm not sure that are they in the main bundle?
It's a separate bundle.
It's a separate bundle, but they are...
Well, I don't have it electronically.
No,
Supplementary.
I don't.
I have the supplementaries.
Oh,
Electronically,
Yeah.
you do?
They're on the shared drive.
Oh, well,
should have it.
I haven't. Well,
Resend it.
found it.
neither of us do. So can you make arrangements for us to have them, please? Thank you.
Vedant's got all of them, I don't.
Thank you.
Should
Not
have.
your fault, Mr.
No.
Gibson. Anyway, there's always something like this that goes on. Always.
I also understand, my lady, that we're in the process of hyperlinking the case to, again, I hope mitigate to some extent, which should improve things.
Well, it's always better if it's done,
Yes, it
but
is.
it's
That's being done.
not inevitable.
My ladies, my lords, I was on what we submit are the significant errors of principle and law that underpinned the judgments of the courts below, and I'm on the fourth and final point that we cite. It's articulated in our case in a few sentences in paragraph 273 at page MS 166, and it's this: that the judge failed to consider what weight to place on the fact that the natural forum, Zambia, is also an available forum for all the parties. Leaving aside access to justice issues, which I'll come to, the claimants have never contended that Zambia is not an available forum for all the parties. The judge dismissed the importance, we say, of the availability of Zambia as a forum and of Vedanta's undertaking to submit to the Zambian jurisdiction on, with respect, erroneous grounds that were not raised in argument by either party and have not been mentioned by the Court of Appeal and are not, it seems, being pursued by the claimants in their written case. At paragraph 79 of his judgment, he said simply that although, and that's MS 444, even though Vedanta have agreed to submit to the courts of Zambia, they're not technically bound by any judgment of those courts. We deal with this in our case at paragraph 273, MS 166.
Yes, your point is there is a statutory mechanism by which you can enforce a Zambian judgment.
That's right. And then he says, thus secondly, I'd be wrong to ignore the possibility that if litigation was conducted in Zambia, Vedanta KCM would seek to strike it out. Or if they lost at trial, Vedanta might put KCM into liquidation in order to avoid paying out to the claimants. And then he refers to another commercial case, which has been referred to elsewhere, called the UOM case. I'll come to that in a moment, but we submit that that possibility was never the subject of submission, or those two possibilities. There was no evidence that could justify that finding, and indeed, if it were correct, it would be a neutral factor, surely, wherever the trial went ahead. But I note my learned friends aren't seeking to rely on this point, either or any of these points. What they are now saying, or are saying, in their case at paragraph 1962 on this point, it's not necessary to turn it up, at MS 349, they say that the court can't have regard to Vedanta's undertaking to submit to the Zambian jurisdiction because, they say, that submission had not been made by the time of their ex parte application seeking permission to serve out. And they say that the court should look at the position at the time of the ex parte application. Well, with respect, we submit that argument is wrong. First, the claimants have never contended that Zambia is not an available forum for the claim against Vedanta, absence access to justice. So at the time of the ex parte application, there was never, the position was that there was no contention that Zambia was not an available forum. And second, at the time of that application, Zambia was an available forum, and the latest submission by Vedanta simply confirmed that position. Just standing back also from the argument, it does seem an extraordinary proposition that a defendant in this situation has to submit, as it were, in an open-ended way before even being served with the claim form in order to be able to take advantage of the fact that there is an available forum. So we submit that the claimant's argument on that point is wrong, and the judge was wrong to ignore that factor. But as I've sought to show, that in effect, we do submit that he treated the approach taken in various commercial cases as effectively determinative, and absent a finding that the claim against Vedanta was a device, he held that that virtually concluded the matter, and there was no proper evaluation as a result, and we respectfully submit that that would give at this court, an appellate court, would have given the Court of Appeal the right to re-evaluate according to law in accordance with the fundamental principle. May I now turn to the third of my topics, and that is the evaluative exercise under the rule and how we submit it should have been carried out and what factors would have been taken into account if it had been carried out. And in short, we say if it had been properly carried out, the claimants could not possibly have discharged the burden of showing clearly that it was in the interests of the parties and the ends of justice that the trial against KCM should take place in England. And you'll note that feeding into this particular ground is a submission that the claimants make in their case, that there's no real difference, they say, between a unitary action and a group action, an action involving one or more parties, and an attempt to found jurisdiction for a group action. And in my submission, as I will seek to demonstrate, there are very, very substantial differences in seeking to found jurisdiction for a group action. So, in order to carry out the evaluative exercise, we submit the judge needed to consider, one, what weight should be attached to the importance of bringing these group action claims against KCM in the natural forum, Zambia. Against this, what weight should be attached to the risk of parallel claims materializing in Zambia if the claim goes on in this jurisdiction against both Vedanta and KCM. And I'll highlight certain factors which we submit underline why the natural forum is such an important factor in this case. And secondly, underline why, being a prospective environmental group action, these claims are so fundamentally different to the sort of commercial cases which were so influential with the courts below. And thirdly, why minimal and certainly not decisive weight should be attached to any risk if it exists of parallel proceedings in respect of these claims against KCM. So may I start with the group action issue? My lady, English group action procedures, as the court knows, pursuant to CPR 1910, enable the court to make directions designed to ensure that claims giving rise to common issues are managed and tried as efficiently, cost-effectively, and justly as possible. Essentially, our procedures are case management procedures. We don't, of course, have class actions for this type of claim. it follows that property damage and personal injury claims such as these always remain at heart individual claims, each with their own facts and quantum. And I'll develop that in a moment, but one overarching point, we submit it is simply not consonant with the core objectives of just, efficient and cost-effective case management for thousands of claimants at vast additional expense and huge prejudice to KCM to be corralled in a forum thousands of miles away from the land which is alleged to have been damaged in Zambia, where the claimants live and which is an available forum to the parties. Secondly, then, you heard me use the phrase that this is an attempt to found jurisdiction for a group action with indeterminate numbers.
Well, couldn't it be tried in Zambia anyway? Couldn't the English court sit in Zambia? It's been done.
Well, the English court could deal with certain issues in Zambia, but at massive additional expense. I don't think an English court could try the large number of claims that it would be necessary to have determined. Assume one had lead cases were tried. Those lead cases might establish in a small number of cases that certain breaches of the regulations, that there was pollution in certain parts. That still leaves in each individual case questions of quantum and causation in those cases. If this was being tried in Zambia, all of those issues would be determined by local district judges, as they have done in other cases. That's the principle that would happen. In this case, it does seem to be, and certainly judges have gone abroad and taken evidence in situations, but to...
Yes, that's what I meant by trying it. I
Oh, I
didn't
see.
actually mean by
Oh, I see. Yes.
usurping the function of the Zambian courts. I meant by going and taking evidence.
Yes, but only that could be done, but my lady, that wouldn't address the fundamental prejudice points and the huge additional multiplication of expense involved in a group action of this type being tried in the wrong forum. And I'm also seeking to underline why commercial cases are so different, because you're dealing with one case. With this type of case, once jurisdiction is founded for, in this case, 1,800, but it could be 1,000, it could be 2,000, the English court then makes a group litigation order, and further claimants, if their claims give rise to the same issues, are entitled to join the group. So that is what will happen, inevitably. And it's not just, my learned friend says, well, there's no evidence about that, but the judge noted in paragraph 9 of his judgment at MS 431 that there's a distinct possibility that the number of claimants might increase significantly. We know it will because there's another firm in Zambia at the moment called Messrs. Hausfeld. They have been taking part in some of our proceedings, and they are waiting, as it were, on the outcome of this hearing, because they have, at the moment, 1,000 claimants from another community who they say wish to either join this action or be a part of it, and at the moment they are in possibly competition with Lead A to be the lead solicitors of the group action. So we know, once jurisdiction is founded, there is another firm in Zambia, English firm, that is, has, they say at the moment, 1,000 additional claimants. And moreover, Lead A are alleging that the pollution is ongoing. It follows that inevitably, if that is the case, this is open-ended. So, my lady, the effect of this is that if jurisdiction is founded concerning the alleged pollution, cases which should surely be dealt with locally are exported on a massive scale to the wrong forum, indeterminately, on an open-ended basis. the individual issue point, which I've already touched on, the cases behind the lead cases, an English court could try some lead cases in order to make general findings for guidance for the rest of the group under our group action procedures. But as I say, it can't try all 1,800, 3,000, 2,000 in the background. Now, it may be said, well, a defendant, once certain guidelines have been given in cases, has the option to settle those cases.
Or establish some sort of claims handling procedure.
Yes.
Takes place out of court by adjudication unless somebody wants to complain about it.
Well, if that is what has to happen, then in my submission, that all weighs in favour of this happening in Zambia. Because that type of procedure, local procedure, is exactly what would happen if the cases are handled in Zambia. And the trouble is, that procedure is still mediated and is still conducted through the auspices of the English lawyers representing the claimants. So their representatives, instead of being local Zambian lawyers, are English firms, and experience shows that there may be real issues in relation to those matters because quantum evaluations from parties can differ. But the costs multiplication in these cases being handled by English lawyers are enormous. The multiplication is on a massive scale. Cost budgeting simply doesn't work because normally in a group action of this type, the defendant would say, we need to have certain information about the claimants in the group because without any information, large numbers of people, and it has been a problem which Lord Wool spoke about when he was bringing in the GLO reforms some years ago, is trying to set the bar high enough so people, as it were, don't just sign on. And what do you make the entry requirements? The trouble is, once an action like this has been exported to the forum non conveniens, any information which it's necessary to obtain from claimants to see whether they fall within the group or they have viable claims is obtained by English lawyers at huge expense. That is why the cost bills in some of these cases have been run into tens of millions of pounds. So next one has the fact that these are claims for injunctions. The claimants are arguing that the English court should make mandatory and prohibitory injunctions against KCM. Such remedies involve the English court exercising a supervisory jurisdiction that we submit in impossibly difficult circumstances, particularly given the extent of the regulation in Zambia. And my learned friend says, well, we would claim damages in lieu, but the fact of the matter is the claims for injunctions are still being made and are therefore part of the forum application. A further point, which again underlines the difference between a unitary action and a group action, is that you can't prevent parallel proceedings in Zambia. If the group action against both defendants goes ahead in this jurisdiction, certain issues will be identified as being common issues arising from 2005 to date. The English court cannot prevent local Zambians bringing claims which give rise to similar issues in Zambia over the next period.
Why would claimants be motivated to do that?
Well, my lord, for the reasons I would say that motivated them to bring claims against KCM in recent years, and there have been claims against KCM, which I'll take you to in access to justice. Not least also because there are NGOs and claimant firms who are active and willing and able to take on these cases.
But why would those firms or NGOs want to take on cases if there were a group action available, a group litigation available in London?
Because why local Zambian lawyers would wish to have the opportunity to bring these cases as well. They shouldn't have to compete, we respectfully submit, and this is relevant to access to justice, with English lawyers. I mean, the point, that there may well be, my lords, my ladies, factors that one could put on both sides of the scales. But as the court knows well, normally in a forum adjudication, the natural forum, the forum that is clearly or distinctly the forum with which the action has its most substantial and real connection, normally determines the issue, unless justice requires that the case should not be heard in that forum. And that is because it is recognised in my submission, and implicit in that is that the ends of justice and the interests of the parties, for a large number of reasons, are best served by a case being conducted in the natural forum. That is the case with a unitary action. When we're contemplating taking a massive land-based group action into the unnatural forum, in my submission those factors weigh even heavily, and it becomes less appropriate to allow principles or approaches adopted in commercial cases with no natural forum, possibly, as it is in many of them, to dominate what the court should do. And going back to where I started, if the proper exercise of the test in this case results in the court saying that England is clearly the natural forum, one really does question when any case could result in a court saying that it's clearly not the natural forum, the proper place, to use the wording of the statute. And that is why the word we submit clearly is included in the test, applying Lord Gough's principle. So, I mean, returning to that fundamental principle, just looking at it through that prism, looking first at the interests of the claimants. If permission to serve KCM is set aside, then the claimants can resolve any hypothetical risk of bifurcation themselves. They can continue with their proceedings here against Vedanta. They don't need to bring in KCM. Their case is they have a right to sue Vedanta. Vedanta owes, on this assumption they've passed through the gateway, they have an arguable claim in common law and under statute. And indeed, they're seeking to uphold the judge's finding that KCM has potentially financial difficulties. And yet at one and the same time, as upholding that finding in order to justify and meet the arguments as to why they're going against Vedanta when they've got a strict liability claim against KCM, they say they wish to bring KCM into this jurisdiction. So they can...
If they just sue Vedanta here,
Yes.
they will want to make use of documents which are in the possession of KCM and evidence about what was happening there. How do they get that?
Well, they would have to make applications, letters of request and so on, exactly the same as KCM would have to do if it was in the same position. And I rely on that as a ground of prejudice for KCM.
But if KCM were joined, there'd be orders directly against them in these proceedings.
Well, they could... They haven't... It's not being suggested that that is the sole reason that they are seeking. I appreciate that is a further reason. The reason being put forward is the risk of parallel proceedings. So that specific issue is not one that's been the subject of argument, but I accept that it is a factor, but it's not the issue that's being put forward and in this particular case, but it weighs just as heavily in the prejudice that KCM, that affects KCM, if it has to come into this jurisdiction. And if one is applying, taking into account Lord Justice Lloyd, Lord Collins's principle, that, in my submission, weighs heavily, particularly when a foreign defendant can demonstrate real prejudice, which is one of the general factors that we say should have been weighed. But on the face of it, they can continue with their claim against Vedanta. Alternatively, they can sue KCM alone in Zambia, which is, of course, a complete answer to the point. Now, one questions why they would want to bring Vedanta into the proceedings in Zambia when they've got their strict liability claims, but if they want to put that point beyond argument, Vedanta has agreed to submit. So the parallel proceedings problem, which was decisive for the courts below, is entirely as a result of various elections the claimants can or cannot make. There's simply an assumption that they will bring proceedings against KCM in Zambia.
Oh, KCM.
In Zambia. So we submit, if one stands back, and the court is enjoined to do that in this situation, those factors are highly material if one's taking into account the prejudice of the parties and the interests of the claimants. On the other hand, if one looks at the interests of KCM, the serious prejudice of having to defend land-based claims with all the points that I've made in this jurisdiction is incurable, is of an enormous scale. They also lose the right to appeal on a point of law. Zambian law, which is normally an important factor in these cases, of course, will be an issue of fact. And they find themselves facing injunctive claims under the supervision, potentially, of an English court. We set out those factors, prejudicial factors, in our case at paragraphs 270 and following, and paragraph 165. And I won't repeat them because the points are made there. But courts below simply didn't conduct this weighing exercise, so those factors weren't taken into account. One then looks at the interests of Vedanta. I appreciate Vedanta is obliged under EU law to defend itself against these mass tort claims in England. But that doesn't mean that on a proper application of the forum test, it's in Vedanta's interests for KCM to be sued in this litigation. And certainly, it goes without saying that it's not. And then finally, the overarching point of the ends of justice, into which we submit the natural forum factors that, and the prejudice factors that I've identified weigh very heavily, and certainly heavier than the assumed risk of parallel proceedings. Lord Collins, as to motive, Lord Collins said in Ultimo, paragraphs 76 to 79, MS 3096, that motive was potentially a relevant factor when balancing forum, and he said that it would better come in at this stage. There was a suggestion as to whether it should come in under the earlier stage, as to whether the claim was one it was reasonable for the court to try. We respectfully adopt that and say another factor that the court can and should take into account when weighing these matters is motive. It's not a binary factor. It is a device or not a device. The court can stand back and look at the pros and cons of, or the reasons, I should say, for the claimants deciding to go against Vedanta in this jurisdiction. Now, Mr. Justice Coulson, the Court of Appeal effectively upheld this, said it's a founding jurisdiction is a reason, clearly, but not the sole reason. And on that basis, he said, how can I say it's a device? But it's not as binary as that in my submission. The court is entitled to stand back And it's not unreasonable, when one stands back, to note that it is an extraordinary state of affairs for thousands of indigent Zambians to want to come to this jurisdiction in order, on this assumption, to overcome the very significant hurdle of proving a duty of care under common law or statutory origin in circumstances where they have strict liability claims in Zambia under Zambian statutes, which give them rights not only to bring claims individually, but give Zambian communities rights to bring claims and give them costs protection. I don't say any of these factors are decisive, but in my submission they go into the balance and should have gone into the balance. So I come back to the rule, and unless one is going to allow the Owusu factor, unless one is going to allow the threat of parallel proceedings to determine the issue, if one allows it to determine the issue, I should say, in the way that the courts below did, in my submission, fundamentally, this rule is robbed of all purpose. And clearly the wording, which we invite the court to apply, is in clear and mandatory terms. The court will not, and so on. And for those reasons, we submit the courts below erred, and the proper answer to this question is that the claimants did not clearly discharge the burden on them. So those are our submissions on forum. I now turn to the final ground of KCM's appeal, which is access to justice. My lady, I won't hand them up now, but I have updated reference documents which give the MS references of the various documents that I'll refer to, which I hope will be helpful to the court. Would you please go to our case at paragraph 277 on MS 168. And I propose to approach this by giving the court an overview of our position, looking briefly at the findings below and the legal principles and the misdirections, and then seeking to highlight the errors in the evaluation exercise. My lady, this ground only arises if the defendants have succeeded on the forum ground, and leaving access to justice considerations, England is not the proper place to bring the claims. So the claimants say, even if Zambia is the proper place, the court should nonetheless not give permission because there's a real risk we will not get access to justice in Zambia. The Court of Appeal remarked at paragraph 133, MS 421, that there must come a time when access to justice in this type of case will not be achieved by exporting cases, but by the local availability of local lawyers, experts, and sufficient funding to enable the cases to be tried locally. This chimes with the evidence of Mr. Masukwa, who expressed his concern about foreign law firms attempting to take environmental work out of Zambia and stating this trend, if successful, will simply stifle the development of environmental law expertise at the Zambian bar and in the Zambian courts. My lady, the error of law at the centre of this ground of appeal is the failure properly to apply the important guidance given by Lord Gough in Connolly as to how an English court should evaluate, with due caution because issues of comity are engaged, the civil justice system of another country, in particular when questions as to funding arise. The substantial justice test, as he explained, requires the court to have proper regard to the norms of the sovereign state it is evaluating and not to apply English norms, what he called or referred to in one part of his speech as a Rolls-Royce model. My lady, the previous Zambian group cases, which I will refer the court to if I may, alone in our submission, evidence the key misdirections which occurred in the courts below. They demonstrate that there are competent, innovative, public-spirited lawyers in Zambia, willing and able to represent these claimants and prosecute these claims with the requisite legal expertise and expert evidence before able, fair, and independent-minded judges using group action procedures based on our own. As I mentioned earlier, the whole point of those group action procedures is so that judges can manage claims involving large numbers as efficiently, expeditiously, and justly as possible. And those procedures operate in Zambia. Two cases, Sinkala and Nyasulu, show local lawyers, an NGO, and local government officials representing the interests of the claimant communities in claims brought against KCM. Indeed, in their particulars of claim in this case, paragraph 38, MS 635, the claimants actually rely on liability findings of the High Court in Zambia upheld by the Supreme Court concerning allegations of pollution of waterways in 2006. Instead of these cases being relied on in the evaluative exercise as compelling evidence that these claimants will be able to get access to justice, and as to the way in which lawyers in Zambia and judges in Zambia will manage them, they were misconstrued with respect and simply ignored. As a result, the courts below failed to take into account a further relevant factor. Namely, these cases corroborate the statements and opinions of very distinguished members of the Zambian legal profession and judicial profession, who testified that the claimants would be able to obtain access to justice, which included the Solicitor General of Zambia, Abraham Wanza SC, and the Honourable Chief Justice Ernest Sakala, the recently retired, longest-serving Supreme Court judge and ex-Chief Justice of Zambia. On the other hand, the courts failed to take into account that these cases significantly undermine the cogency of the claimant's evidence, which we respectfully submit was substantially based on what Lord Gough would have called the Lead-A Rolls-Royce model. The Lead-A particulars of claim are 63 pages. The norm for a particulars of claim in Zambia is 3 pages. Hearings last days, as opposed to weeks. It's shorter. Lord Gough used the phrase rudimentary. It doesn't mean that justice, substantial justice, isn't being done. It's just different. And there is no significant dispute now that the Zambian judicial system has been the subject of major reforms driven forward by Chief Justice Mambalima. And her, if I may respectfully say so, astonishing efforts have resulted in a fully functioning and efficient system with new courts of appeal, more district courts, and the delays, which were a problem which bedeviled the system, now no longer an issue in Zambia. Trials taking place within 2 to 3 years, as Chief Justice Sakala said, appeals within 12 months. So, my lady, in my submission, what went wrong, if I may put it like that, at first instance, and the Court of Appeal essentially again, did not interfere with the decision of the judge at first instance, and held that it was a decision he was entitled to reach. And what essentially went wrong here, we respectfully submit, is a failure to apply, as it should be applied, the substantial justice test, particularly having regard to the fact that I can show you cases where indigent claimants have achieved justice in Zambia. And it is an extraordinary state of affairs that that is the case. Turning to the findings of the courts below, which I'll deal with very quickly, and we summarise them in our case at 279 through to 283, MS 168 to 170. And the learned judge stated, and this was the finding that I challenge, and I respectfully submit it was only possible as a result of a misdirection of the type that I've identified, that the claimants would almost certainly not get access to justice if these claims were pursued in Zambia. He identified correctly, and it's agreed, that CFAs are unlawful in Zambia, and therefore he said fourth, and it's the fourth and fifth grounds that are the nub of his decision, that the only remaining theoretical funding possibility that would allow these claimants to bring these claims is for lawyers to take on the claimants on the payment of a small upfront fee, pay for the disbursements, including expert evidence, out of their own pockets, and then to recover the costs when the claims are successful. So there's no dispute, and the judge didn't find that, in theory, we would say in practice, in Zambia, these claims will be brought by lawyers obtaining a deposit up front. This is where I'll show you, we submit not an adequate summary, but also by finding other ways, which they do in Zambia, to fund these cases, and then deferring, insofar as they've obtained a deposit, deferring the payment of costs. And he went on to find that it was unrealistic to suppose that lawyers would fund such, and please note, my lady, large and potentially complex claims, essentially out of their own pockets. And he went on at 5 to consider it's not been shown that there are private lawyers with the relevant experience who are willing and able to take on the claimant's claims in Zambia. So those are the key findings which I will seek to show you demonstrate a misapplication of the test. Then, crucially, you see we have summarised at 281.1. He then looked at what he called the track record of Zambia litigation of this kind. And essentially said, there have been particular cases drawn to my attention, but they could not give an aspiring litigant in a group action dealing with environmental issues any confidence that they would be appropriately managed and resolved. And he dismissed them, which is why I can submit properly that these cases were effectively not taken into account. Now, if we go to principles, they are at 290 of our case. And there are two fundamental points of law I seek to highlight. First of all, 290, the test. We are agreed on the test, which Lord Collins delineated in Ultimo. The burden is on the claimants to demonstrate against an objective standard supported by positive and cogent evidence that there is a real risk that substantial justice, we've put cannot, it's sometimes said as will not, I don't think anything turns on that, be obtained in Zambia. A real risk against an objective standard supported by positive and cogent evidence that substantial justice will not be obtained in Zambia. As I say, 2 points. First of all, he stressed that the threshold is high because issues of comity are involved. One has to be extremely cautious, as he said, when deciding that there is a risk. Secondly, then, moving to Lord Gough in Connolly, as we do in 292, and looking at questions of funding, we've quoted it. And could I just highlight 5 points from the quotation we've included in 292 and then over the page in 294 and footnote 378. They are, first of all, he said, and it actually starts a little earlier than we've quoted, with a general principle may be derived, which is that if a clearly more appropriate forum, and now I'm reading from the quote, has been identified, generally speaking, the plaintiff will have to take that forum as he finds it, even if in certain respects it's less advantageous to him than the English forum. He then talks about lower damages and so on. And then he says the same must apply to system of court procedures, including the rules of evidence applicable in the foreign forum. This may display many features which distinguish it from ours and which English lawyers might think render it less advantageous for the plaintiff. Such a result may in particular be true of those jurisdictions of which there are many in the world, which are smaller than our own and are in consequence lacking in financial resources compared with our own. But that is not of itself enough to refuse a stay. And it's against that backdrop that he sets out the substantial justice test. Second point is in the following paragraph, where he identifies the fact that if the position had been that the plaintiff was seeking to take advantage of financial assistance to obtain a Rolls-Royce presentation of his case, as opposed to a more rudimentary presentation in the appropriate forum, it might well not be necessary to take a different view. And I highlight that because I've used the word rudimentary in my case, and my learned friend has picked me up on it. I'm using shorthand, Lord Gough's term. I'm not suggesting for a moment that rudimentary presentation does not mean that it would not be possible to get substantial justice. I'm simply referring to the fact that it may not be as complex and expensive as the sort of presentation and the sort of group action approach that would be adopted here. And then over the page, he then said, at least as a general rule, we've quoted at 294, the court will not refuse a stay simply because the plaintiff has shown that no financial assistance, for example, in the form of legal aid, will be available to him in the appropriate forum, whereas such financial assistance will be available to him in England. And then stated, the availability of financial assistance in this country, coupled with its non-availability in the appropriate forum, may exceptionally be a relevant factor in this context. And we've quoted further from his speech with the references in footnote 378, where again he touches on some of the difficult policy issues that are involved when one is comparing the way different sovereign states finance litigation. And he remarks on the fact that in this country until 1949 we had no legal aid. We know in this country when we did have legal aid, it would often be said that if you were just above the legal aid limit, it was impossibly difficult to be able to afford access to justice in this country. The CFA regime, making lawful arrangements that were unlawful, has changed the goalposts. But these are all very difficult, finely balanced issues which underline why we submit Lord Gough's words are so important, and a proper application of the substantial test, having due regard to issues of comity, is so important. So, my lord, my ladies, it is those tests which underpin my legal submission. Lubby and Connolly are two cases, and they're referred to in our case at paragraph 295 and 296, which the claimants rely on heavily. Connolly, the case in which Lord Gough made those statements, is a case in which the claimant was suing in respects of laryngeal cancer, which he alleged he had contracted as a result of exposure to ionizing radiation at a uranium mine in Namibia. In that case, it was conceded, there was no issue before the House of Lords that he would not be able to obtain legal representation and expert assistance to prove the very difficult issues of radiation-caused cancer and so on in Namibia. So that there was it was a stark choice. It's what Lord Bingham in the Court of Appeal described as a stark choice. No justice in Namibia, access to justice here. And in Luby, which we refer to in paragraph 296, again, when Lord Bingham was looking at the position in South Africa, in those days, he was presented with what he described as you can see from our quote, clear, strong and unchallenged view of the attorneys who provided statements. There was no firm of South African attorneys with the expertise in this field, the means, who would undertake the risk of conducting these proceedings on a conditional fee basis. So again, we respectfully submit it's a completely different situation. In South Africa at the time, there were no group procedures, there had been no similar cases, and in any event, the evidence was clear. So my lady, we summarise the misdirections of the courts below, and I don't think it's necessary for me to repeat what is in paragraph 284, but that's where they are. What I'd like to do is show you, if I may, some of the cases I'm referring to, because they, in our submission, make good the points that I've made in opening, and then one stands back and asks oneself, how are we judging the Zambian justice system if these are not taken into account? And the starting point we submit when looking at funding is paragraph 300 of our case, which is not just funding as it were in isolation. One has to look at funding in the context of the system as a whole and the rights and remedies which the legislature has provided to Zambians in respect of these types of claim. And that is what we highlight in paragraph 300. None of the matters I'm taking you to and will take you to are the subject of dispute to any material extent. This is all uncontested material. May I just highlight one or two of the points we make in our case at paragraph 300.1 to 300.6. First, 300.1, the Zambian legislature has enacted a suite of environmental statutes making mining companies such as KCM strictly liable, clearly designed to ensure that claims of this type can be brought before the Zambian courts. Secondly, those statutes give the claimants costs protection, so they are not vulnerable to costs, orders against them. Thirdly, those statutes provide obligations on mining companies such as KCM on a regular basis to carry out testing, provide samples, provide reports of their emissions. So there is documentary evidence available as to when they have exceeded those limits. Next, the statutes actually provide communities with remedies. Claims can be brought not just by individuals, but communities have standing. And finally, NGOs have standing to bring cases in their own right. That, in my submission, is a very important starting point against which to judge whether or not there's a risk that these claimants will not obtain access to justice. Secondly, and it's agreed, there are group action procedures. There are cases showing judges in Zambia using the group action procedures in exactly the same way that we do here. Trial of lead cases, findings on liability, and then exactly the sort of procedure that my Lady Black was mentioning, as would happen here. Individual cases, quantum and other issues can then be tried in local courts by local district judges, and so on. All of that can happen. And then finally, to highlight point 300.6, which is the role of local district agricultural coordinators and district commissioners. In Chingola, in Zambia, the government officials, the district commissioner, representing the president of Zambia at a district level, acts as a first point of reference for any complaints. The local district agricultural coordinators assist indigent members of the communities, including the claimant communities, to investigate complaints and take appropriate action.
Mr. Gibson, did you refer to local courts a minute or two ago?
Yes.
That chimes with the Attorney General's intervention.
Yes.
Let me just get one thing clear. It may be my fault, but I've only found his application to this court to become an intervener. And I, of course, once found that in Supplementary Volume 4, MSA 25. I get the impression from the index that this stands as his case under the intervention.
Correct, my lord, that is right.
If so, you'll remember that he says at 4.110 that a local court shall administer only African customary law. And I think he goes on to say there's no legal representation. Were you invoking local courts for quantification of damages here?
Yes.
And if so, were you right to do so?
Yes, I am, my lord. He is referring to, he's dealing with an allegation that there's a shortage of lawyers in Zambia. And one of the points he's making there is that a very large number of disputes, particularly disputes of this type, are dealt with through what is known as Zambian customary law, which do not involve the courts. When I talk about local courts, I am talking about local district courts in Kitwe, for example, which is in the area and where local cases have been tried. That is the local district court. Other claims have been brought in Lusaka. But
And they can hear statutory
yes, absolutely. They are like our
alleged breaches of statute.
yes, absolutely. They're like our county courts with it, and they can and do hear those cases. So, and I'll show you how that
Very well.
this is happening. What's the other place called? Kitwe. So, just going back to our case, if I may, that we say is the starting point. I've dealt with funding, the evidence before the court as to how funding takes place in and the references for that are given in the case. May we go to the past and ongoing group claims in Zambia, which demonstrate the points that I have been making. There are details of 7 relevant group claims which have been identified. We cover them at paragraphs 305 to 323 of our case, MS 182 to 191. There are many other examples of group claims involving employees and workers, but they're not of the same type, so they haven't actually been referred to. There's no dispute about that. My ladies, my lords, the references for the pleadings, judgments and documents associated with these cases are in an appendix to this section, and we'll be handing up an MS referenced appendix. The judgments, which I commend to you in the cases I'll identify in the pleadings, and the records of proceedings are in Part 2 of the appendix, File 9. And if we go first to Sinkala to show local justice at work in this community in Zambia, we deal with it at paragraph 317 of our case on page MS 187. None of this is in dispute. This is based on the statement of the district agricultural coordinator in Chingola at the time, who's recently retired, Mr. Philip Simbuli. References are in the case. He describes how in 2006 he was approached by 2 farmers from Shumalala on behalf of 60 who had farms along the Mushishima stream, which is the same rural community, one of the streams we're concerned with. He brought the complaint to the attention of the district commissioner. With the assistance of a field officer, he inspected the farms of 60 farmers. He determined the level of damage, took into account areas affected, type of crop growth, and an income figure. He held meetings in the local communities, and other farmers came forward. Now, you will have seen in the evidence of the claimants, and you will have seen that the judge dismissed the role of NGOs working in this area. The Citizens for the Better Environment became involved with this claim, and they issued proceedings against KCM on behalf of 71 indigent farmers. We have the statement of claim at MS 2857. A firm of attorneys, Messrs Makumbi and Co. from Kitwe, a local town, not far away in Chingola, represented the claimants. What in fact happened was that there were negotiations, also facilitated by the Zambian government, between KCM and the farmers. A settlement was agreed. A settlement figure of 500 million kwacha, approximately £65,000, was agreed. There was an open meeting in Shimalala attended by the farmers. Payment was made by cheque. A bank account was set up because none of the claimants have bank accounts to enable them to cash the cheque. And the 52 cheques were produced. Mr. Simbuli's unchallenged evidence was that if the current claimants approached the District Agricultural Office or the District Commissioner, he would expect that they would conduct a similar exercise. And there's no reason why the procedure couldn't work with more claimants. There only having been 72 involved in the Sinkala case. Now, there you have concrete evidence, cogent, positive evidence of this local community securing the assistance of an NGO, local lawyers, and obtaining access to justice. Proceedings issued and the claim was settled. The judge, if I may respectfully say so, was distracted by the claimant's one point on this case, which you will see summarised at paragraph 320. Their one point was that Mr. Day had identified that 35 of these claimants were also suing in this case. He'd spoken to them, and 16 of them, of that 35, said they hadn't received their cheques. Now, that's surprising because Mr. Simbuli is an independent witness and his evidence was that a bank account was set up and the 52 cheques were presented. But he said there's a dispute on the facts which I can't resolve, paragraph 192 of his judgment. And the Court of Appeal, in reviewing that, essentially said the same thing. There's a dispute on the facts. Well, my point is that just assuming there is a dispute on the facts as to whether 12, 15, 19 of these claimants received their cheques, if one is applying the substantial justice test, fairly inappropriately, we would say, what this case demonstrates is local justice working in the local community. Contrary to the judge's findings and my learned friend's submissions, an NGO, the Citizens for Better Environment, actually issuing proceedings. The proceedings relying on exactly the same statutes, strict liability statutes that we are, damage to land being assessed by a local person, the Lusaka School of Agricultural Sciences giving expert evidence on behalf of KCM, and that evidence chiming with the evidence of the District Agricultural Coordinator, undisputed evidence of the procedures ongoing, and in fact, Mr. Simbuli's evidence was that KCM were collaborative. None of this was taken into account. It was dismissed because the judge focused, I respectfully submit, not on the substantial justice test, but on the outcome and whether or not all the checks were cashed, which cannot be, with respect, the right approach. One then comes to the case of Nyasulu. which we deal with at 306 of our, paragraph 306 of our submissions. This is a case Nyasulu and 2,000 others. In this case, 2,000 members of the Chingola community alleged pollution of the Kafu River and brought proceedings against KCM. The statement of claim, which is a 4-page document, and the notes of evidence, and the judgment at first instance, and the judgment of the Supreme Court are all in file 9, as I said. And as I said earlier, the claimants actually rely on the findings in this case, in these proceedings. So this was a group action involving 2,000 claimants. The claimants were represented by a lawyer, Mr. Bwala of KBF and Partners. Locals operated through an executive committee. There was a trial in Lusaka. And again, looking at the way these matters are dealt with in Zambia, they joined the regulator, the Environmental Council of Zambia, as a co-defendant, precisely so that the regulator would be able to give evidence against KCM by producing the test results, the samples, and a report, and all the necessary expert evidence required to prove the pollution. The plaintiffs called victims of the pollution and expert evidence to show there was pollution. And if you look at our footnote 417, we've summarized some of the findings of the judge in relation to the footnote issue, the pollution issue. But as you can see, he is making findings that there was an excess of the levels required by the inspectorate, and these levels will cause harm to fish, frogs, crocodiles, and hippos, and aquatic plants, and will harm people. And there were further findings about the colour of the water and so on. And we refer to the fact that the Environmental Council of Zambia produced a report. So these detailed findings on liability made by the judge were upheld by the Supreme Court. Now, may I just pause there in the argument? How could it be said that the claimants in this group action could not get access to justice? I ask rhetorically. If that was where the position ended, a finding on liability and a finding confirmed by the Supreme Court. Surely that would be, I respectfully submit, very, very compelling evidence that they could. And in my submission, it remains compelling evidence because what happened doesn't undermine that. On appeal, the Supreme Court, I should go back to the judge, awarded all 2,000 claimants damages. Even though he'd only had medical reports, they were claiming in respect of personal injury, I should have said, and not damage to land. Even though he'd only had medical reports, but records sufficed to prove personal injury, from 12. And based on that, he awarded the entire group a lump sum. And the Supreme Court said that was the wrong approach and that they upheld the findings on liability, but I quote from their judgment at A92970, the learned judge should have ended at making a declaration as to the appellant's liability and then ordered that each of the claimants carries out an individual assessment to ascertain the extent of injury. And in a further part of the judgment, and this goes back to my lady's point, having established that the appellants had polluted the claimant's river source, the learned judge should have referred the matter to the learned deputy registrar for assessment. That's the local district judge. So there was a procedural error. And yet, one asks, well, how was this evidence of access to justice dealt with? The judge dismissed it because, and my learned friends rely on this, because it ended disastrously for so many of the claimants. We don't know how many of them, in fact, had legitimate claims, but I accept there were 2,000 in the group. And as a result of the finding of the Supreme Court, only 12 were, as it were, permitted to seek to have their damages assessed, and the rest of the claims were dismissed. I help, my lord.
I'm trying to make a note of where the Supreme Court judgment is
Yes.
for my reading tonight.
I'm so sorry.
And I'm afraid I've not yet vacated it.
I do
I'm
apologise.
trying to find A9105.
I see.
And
It's
not in authorities.
It's not in authorities.
It's-
It's in part 2 of the appendix.
Part 2 of the appendix.
Yes.
Right. Core Volume 2.
Part 2 of the appendix. It's volume 9.
Volume 9.
It'll be a blue or a white one.
It'll be,
Yes.
Something like that.
you'll find it.
So that's,
Oh, there. Hold on.
they're
Those
all
are the
collected in
authorities.
104.
Forgive me. I'm so sorry,
Yes.
Mr. Gibson.
Not
I
at
found
all.
it.
No, my lord, of course. So
Yes?
the learned judge dismissed this case as evidence and indeed weighed it on the other side of the scales because, as he put it, it ended disastrously. So I respectfully submit, instead of seeking to apply the test and looking at what this case actually demonstrates, local lawyers bringing a group action, establishing pollution, and so on, he focused on the fact that a mistake was made. But there's an illogicality here, because no one is suggesting that if cases are brought to before the Zambian courts, they cannot be competently and properly progressed and managed. The sole argument is the difficulty is funding them to go to court. And dismissing this case because there was a mistake by the judge or by the lawyers who brought it would be equivalent of saying you couldn't get access to justice in this jurisdiction because the benzodiazepine litigation would collapse disastrously, or the organophosphate litigation. One can think of countless examples where group actions have gone wrong for different reasons. But it doesn't mean that the system is not capable of providing access to justice. So Lee Day, in relation to both those cases, make the point fairly that there were delays, and there were delays. But as I've shown you, Chief Justice Mambalima has dealt with that. And that's not a problem now going forward. So
If we look at the judgment of the Court of Appeal in the case you're talking about, the Nyasulu case.
Nyasulu, yes.
In fact, am I right in thinking that what they ordered was, in relation to the damages, it did exactly what they said the judge should have done, which is send them back, set aside the awarded damages in favour of the respondents and order that the matter be sent back to the Deputy Registrar in the court below for assessment of damages. But only in
12.
respect to the respondents'
In the
medical
12.
reports, but not the rest.
One might have expected that in
Yes.
fairness. But they did send it back for the 12. And
Yes,
so
but not for the others.
it was dismissed for the others. But what thread is this hanging by, if it's the difference of a case, which is there's access to justice, but if there's a misdirection, there isn't access to justice. And it's very interesting that when this all started, Mr. Day's evidence in support of his permission to set aside had one line about access to justice only. And the argument was concern that maybe his claimants may not be able to take advantage of this judgment. It's shifted. And that is because in my submission, the claimants were well aware of the fact that this case presented serious issues for them. What it does demonstrate is members of a local community retaining a lawyer, bringing a case in the High Court in Lusaka, joining the regulator to take advantage of the regulator's evidence, successfully proving pollution, and using, and this again is an example of, if I may use the term, more rudimentary justice, the Supreme Court accepted that medical records alone would be sufficient to prove personal injury. It's a well-known case in Zambia, and therefore one's entitled to, I think, infer, and there's certainly evidence to this effect, that Zambian lawyers are well aware of the mistake that was made in that case. And there was evidence before the court from a Mr. Musukwa, who's bringing a group action at the moment, and he described how he is putting in place procedures to ensure a similar mistake is not made. But that's not the end of it, my lady. One then goes to paragraph 322 of our submissions, and there is another case we refer to, and the papers in relation to this case are also included. This is a case brought by the Citizens for Better Environment again, against Bwana Makumba Mining Limited. It's a representative action. There's another firm of lawyers, Messrs. Peter Chamatangi and Co., who you can see from the statement of claim at MS 2803. It's brought in the court that I was referring my Lord Wilson to, the local district registry in Kitwe. It's 16 farmers alleging pollution of a local stream in the Copperbelt region. They rely on the same strict liability provisions as by the claimants in this case. The regulatory authorities gave evidence on behalf of the claimants, and we have the judgment, so you can see it. The one in file 9 is unclear, and the better one we highlight in footnote 453 at AB 12, 1, 2, 3, 6737 to 6759. But the regulatory authorities again give evidence, and the claimants, using the regulatory authorities, namely the NGO, obtained an environmental impact and social impact assessment reports. The claimants were awarded damages by the judge. Madam Justice Makungu ordered awarded the claimants damages and ordered the mining company to conduct various remedial measures. Now, this case, again, is, I would have thought, very powerful evidence of access to justice for similar types of claimants in Zambia. Mr. Justice Coulson dealt with this at paragraph 194 of his judgment. It's not necessary to go to it, that's MS 465, by saying this: there may have been other cases in which environmental claims were handled more successfully than those noted above, and that was his reference to Sinkala, Nyasulu, and a case called Benson Shimulala. But the fact of the matter is that the particular cases that have been drawn to my attention could not give an aspiring litigant dealing with environmental issues any confidence. The case was not mentioned by the Court of Appeal. Again, it's the same area, the same provisions, involvement of an NGO, and so on. There's a further case, and this is the last one I'll take you to, which we refer to at 322.2, Sipisu Stengu and the Puma Energy Zambia Limited. This is a case that Mr. Masukwa gave evidence about because he's the solicitor conducting it, detailed evidence about using group action procedures. 200 claimants in the Copperbelt region again with the assistance of an NGO, this time the Centre for Trade Policy and Development, joined as a co-plaintiff, who assisted the funding, and they provided a deposit of $2,000. But Mr. Masukwa, the lawyer representing the claimants, describes in his witness statements how he's already won an interlocutory hearing securing cost protection. He's obtained discovery of important testing and monitoring records from ZEMA, the Zambian Environmental Management Agency, who he joined as a defendant for that purpose. And his firm are funding the costs of various experts from the University of Zambia and the University Teaching Hospital. And he explains in detail how he'll take it through to trial. So, my lady, there are two more cases referred to in the evidence at 323 of our case. And then at 324, we make submissions. And I respectfully submit that when one looks at these cases, one then considers findings that I took you to. It's theoretical that lawyers would take on cases on behalf of indigent claimants. There are not lawyers ready and willing in the area to do so. There are no NGOs ready to assist. There's no source of funding, effectively, other than the lawyer out of his own pocket, and yet one sees an NGO there providing funding in that case. One sees damage to land being proved, albeit not with huge numbers of the experts we might have here, but by by joining the regulator as a defendant and so on, so you can prove damage to land using their evidence. The points that I've made very briefly, pulling it together, or trying to, are made, as I say, in our case at paragraph 324 to 329, and at paragraph 332 of our case, where we summarise how, applying the substantial justice test, these claims would be brought in Zambia. It's very interesting that the claimants essentially make 2 points repeatedly in relation to these cases. One is delay, and I've dealt with that. The second is that they are smaller cases, bar one, which ended disastrously, as they put it, which is Nyasulu. One moment, please. At paragraph 225 of their case, MS 360, having said at paragraph 238, none of the cases provide any support for KCM's position. KCM's suggestion that NGOs would be likely to fund this litigation is without foundation, paragraph 233. And then, on numbers, KCM is unable, at paragraph 225, to cite any examples of claims of this size being successfully litigated by law firms in Zambia. My lady, note successfully and of this size. In other words, because of the Bwana case, they have to accept that there is an example of a smaller case being successfully litigated. And they have to introduce the success as a criterion to deal with Nyasulu, which was successful on liability, but they say ended disastrously for a lot of the claimants. So that one sentence in my submission is very indicative of where they have moved to in seeking to deal with these cases, although asserting that they provide no support. Which brings me to the point of numbers, which underpins a lot of the submissions. There are large numbers. As we say in our case, and I'll find the reference, numbers, that submission is erroneous, because numbers make the litigation more viable, not less viable. It seems extraordinary to say, when Zambia has group action procedures, which we accept, you can get access to justice for 20, 50, 100, 200. But you can't get access to justice if there is a greater number, leaving aside Nyasulu. Particularly in circumstances where it's acknowledged that there are group action procedures. And so I think there's no disputing, once the case is in court, it can be appropriately managed. So again, we come back to the lawyers, and it said it would be too expensive for lawyers to gather together this group. But that is an extraordinary indictment of Zambian lawyers and their ability to do what lawyers would do if they were simply seeking to gather together a group. And there's evidence about it, using local communities and so on. But of course, once you've gathered them together, because there's cost protection, you can stay all their cases and just proceed, as we would here, with a trial of a smaller number of lead cases. Which brings me to the other side of the balance that didn't happen properly, we say, which is paragraph 335 of our case, which is the lack of cogency, applying the test, of the claimant's evidence. We've included references in the appendix, but we've given a quote here from Brigadier Siakatima, and as you can see, we've underlined it. It's a complicated case such as that set out in the particulars of claim. A case like that set out in the particulars of claim. A number of the Zambians who gave evidence clearly were shown the particulars of claim, the 63-page document, and their evidence saying that these cases would present difficulties for Zambian lawyers, in my submission, is premised on the lead-A model, which is not the sort of cogent evidence that one would expect to see applying the test. And then, as we say at 335.2, at page MS 201, it's also premised on the erroneous assumption that the number of claimants makes it harder rather than easier to obtain access to justice, and we set out the points that I summarised there in relation to that. My lady, the claimants are seeking to suggest that Mr. Ogilvie in his evidence has in some way accepted that the level of expert evidence they say would be required in this case, and I'll simply give you the references for what he actually did say, rather than go into the point, and it's if the point is made in relation to Mr. Ogilvie's evidence, his evidence is actually paragraph 19.3c of his witness statement at MS 795. The other main point is that I'm suggesting that you should encourage Zambian lawyers to flout the CFA rules. That's not what's being said. You've seen how the cases are brought. The judge did not make a finding, and it wasn't the case, and there's evidence the other way from the Solicitor General, from the Zambia's leading costs expert, that the norm in Zambia is to take a deposit up front and then defer fees. It's then a matter for the Zambian lawyer whether or not he enforces the fees. There's nothing wrong, unethical in that at all, and there was no finding by the judge, and that's clearly, we don't know exactly how, but that's clearly how these cases have been brought. But you also have funding from NGOs, as you've seen, and you also have NGOs willing to bring cases. The final point is the judge also took into account what he called two other factors. One is KCM's obduracy, and you've seen the evidence from Mr. Simbuli about the collaborative approach in Sinkala. That obduracy was based on a number of commercial cases where he's drawn adverse inferences, and I do respectfully draw the court's attention to the rule in Hollington and Hewthorne, and the section of Phipson on evidence which outlines it at MS 1664 to the effect that findings of fact in another case are not evidence as between a claimant and a stranger, but you'll see the extent to which findings in commercial case have infiltrated the reasoning we submit quite impermissibly. And secondly, he did say that he couldn't leave out a finding by Mr. Justice, or a statement by Mr. Justice Musonda, that KCM had been shielded from criminal prosecution. State corruption is not relied on by the claimants. At footnote 363 of our case, we quote from Mr. Day's statement where he says, although state corruption is an issue, the claimants do not contend that levels of corruption are so high in Zambia they will be unable to obtain justice on account of this factor. So that is not an issue the claimants have ever taken into account, and it was one of the factors that the judge, we respectfully submit, took into account. So, my lady, I trespass into fact, I know, but it's impossible to demonstrate to you the force of our submissions without showing you cases. And in my submission, cases are not evidence in the sense of preferring one party over another. And if what I've said is correct and a fair summary, and you'll see the cases themselves and the judgments, obviously, of justice working in Zambia, with respect, how can it be said that the test has been properly applied with due regard to caution? How can it be said that Zambian lawyers are simply not ready or willing to take on these cases? And I haven't taken you to the evidence of Zambian lawyers who actually said they were ready and willing to take on the cases. That's in our case. I should just literally draw your attention to it, no more. That's paragraph 334. And also paragraph 330, which was the evidence of how the claims would be brought in Zambia, which again was the only, we would say, cogent evidence before the court, with Zambian lawyers saying things like they noticed that Lee Day were going to put 9 to 10 people on the case. Nothing like that would ever happen in Zambia. You simply would not have that number of lawyers on a case, and so on. So for those reasons, we respectfully submit that the real issue test, the claimants did not, on this case, overcome it. The findings of the judge was wrong, and that error is manifested in a failure, essentially, to apply the carefully worded guidelines, if I can call them that, or points made by Lord Gough in... Thank you very much.
My ladies, my lords, I'm very conscious of the time. I have 15 minutes. This is in relation to Vedanta's appeal. There are 2 grounds of appeal, and they are set out in the case. Behind tab 6 is ground 4, and then behind tab 7. Ground 4, behind tab 6, MS 208, I can take very briefly indeed. That is precisely the counterpart of KCM's ground 1. If KCM succeeds on that ground, then it follows logically that so should Vedanta in relation to the strikeout. The claimants in their case do not seek to argue to the contrary of that logic. They merely suggest at paragraph 69 of their case that it's somehow telling that no strikeout application was made. My submission, that's not telling. There's no such application in either of the Shell cases or the Unilever cases, which were similarly struck out. What happened was, as a matter of logic, it was accepted that if the subsidiary won in relation to the real issue test, then it followed that the claims against the parent company should be struck out. And that is the outcome that clearly Vedanta commends under ground 4. In relation to ground 5, that is the stay ground as it has been described, and that's at MS 209. Vedanta's position in relation to this is that the courts below were wrong in principle to dismiss Vedanta's application for a stay, or certainly the application for a stay could not properly have been dismissed without a reference to the Court of Justice of the European Union having first been made, because of the twin issues of abuse of EU law that were raised and of the scope of Owusu, effectively, in relation to this type of case and in those types of circumstances. This aspect of the appeal, therefore, primarily of importance if KCM is successful on its appeal on grounds 2 and 3, forum and access, such that Vedanta is left facing the claims that have been brought against it. The decisions of the courts below we summarise at paragraphs 362 onwards in our case, MS 155. 2 very short preliminary points. The first is Vedanta, as it has accepted throughout, is domiciled in England and therefore accepts that it is subject to Article 4 of the recast Brussels regulation. Subject to this regulation, persons domiciled in a member state shall, whatever their nationality, be sued in the courts of that member state. So, entirely accepted. The second point is that Vedanta is not seeking to rerun or reopen the European Court's decision in Owusu. That is not its position. Claimants keep asserting that this is a hopeless attempt to do so. The reference issue that is raised, and it's set out at paragraph 387, MS 218, and then at the end there's a draft example reference, raises 3 novel issues of EU law for determination by the European Court, issues which were not considered at all, whether in Owusu or otherwise, previously by that court. In the time available, I'll seek to make 6 points very swiftly indeed. The first is in relation to the purpose of the regulation, and we have cited at paragraph 368 of our case, MS213, the Hypotechny Banker case of 2011, in which the European Court emphasised that the purpose of the regulation is to guarantee to the greatest extent possible the protection of defendants domiciled in the EU. Those are strong and unequivocal words, to guarantee, not just to promote, to the greatest extent possible. Second, the regulation, including Article 4, applies whether the claimants are domiciled in the EU or not. Again, that is accepted. That was confirmed by the European Court in the Group USA reinsurance case, AB 11113 MS 6403, and we've cited at footnote 554 of our case. But one does need to be clear as to what that means. The effect, of course, is the claimants are free to sue Vedanta in Zambia, naturally. The regulation cannot stop that. But they are also free to sue Vedanta in the EU. If they sue within the EU, it has to be in England because there is a duty on the courts of the member states to see that that is done. That's slightly different from the way the claimants put it when they talk of a right to invoke the jurisdiction of the English court, as they do, for example, at paragraph 51 of their case. Article 4 is not concerned with granting rights in that sense to non-EU citizens. It is a duty on the court. Thirdly, as we say in our case, paragraph 425 MS 232, the effect of the European Court's judgment in Owusu has led to what in my submission was an unforeseen effect, and is also a paradoxical and unintended effect, namely that it has incentivized, in effect, English law firms to bring these types of mass tort claims against English domiciled parent companies for a collateral purpose, for a forum shopping purpose. And as we saw in this case, the judge described that as no option, effectively, was the submission being put. No option but to grant jurisdiction over a third state company. And this is one of a series of cases, as this court is aware. Not only this case and the two Shell cases that the Court of Appeals dealt with and the Unilever, Mr. Justice Fraser in the Shell cases at paragraph 40 refers to a previous case as well, brought by Lead A, the Bodo litigation, and he just describes at paragraph 40, that's AB4 tab 53 MS 4327, the fact that in that case effectively a deal was done so that, as he describes it, the parent company, the claims against the parent company, Royal Dutch Shell, ceased on the subsidiary agreeing to submit to the jurisdiction. And that was the first of these types of cases brought under this same model of purported parent company liability. Whatever the intention in terms of Owusu, it was not an intention in my submission to make Article 4, turn Article 4 into something which attracts claims for a purpose entirely collateral to the principle upon which Article 4 is based, being provision to guarantee protection to EU defendants. That was not the intention of the ECJ, that must be clear. Fourth, the findings of the judge in this case, the judge recognised the existence of the Owusu effect, paragraph 76, MS 444, and stated, I am sure that the fact that Vedanta are domiciled in the United Kingdom is one of the principal reasons why they have pursued these pleadings. I'm therefore sure that the claimants, or more accurately their legal advisors, have much in mind the potentially beneficial spin-off that arises. However, he then directed himself that under EU law, he could only stay the claims against Vedanta as an abuse of EU law if it was the sole reason for the claimants bringing those claims. He found at paragraph 77 of his judgment, I cannot say that it is their sole reason. And our position on that is that even if that were the test for misuse, abuse of EU law in these types of circumstances, then we say the judge did err in determining that such a test was not satisfied, and we've set out the reasons for that at paragraph 408, MS 225. And in summary, the findings that he made, some of those findings simply were not supported by the evidence in relation, for example, to the failure of KCM, as he found it, to file accounts with the equivalent of Zambian's company house. That was dealt with in correspondence after the hearing. The evidence simply wasn't there, and just for your note, that is in Appendix Part 2, File 8, Tab 85, MS 2657, 2669. It was simply a difficult and laborious process for the lead agent to obtain those accounts, and he hadn't been able to do so in the time available. And then at 410, paragraph 410, MS 228, we set out the factors which we say the judge should have taken into account, but failed to do so on this sole test. But fifth, we say, point of fundamental importance here, the point of principle, is that the judge, the courts below, could not properly be satisfied that in the circumstances of this type of case, EU law would require anything approaching such a high or confined test as the sole object test. And we say that because it simply cannot be right to try and read over a test that has been applied in a different context to this context of Article 4. And as we state in paragraph 398 of our case, the European Court has so far not provided a definition of universal application in respect to the concept of abuse of EU law. It is derived, as Lord Sumption noted, and as we quote at paragraph 398 in the case of Preston Petrodel in 2013 at paragraph 17, it is derived from the civil law jurisdiction's concept of abuse of rights, and that, as he has summarised it, is these examples illustrate the breadth, at least as a matter of legal theory, of the concept of abuse of rights, which extends not just to the illegal and improper invocation of a right, but to its use for some purpose collateral to that for which it exists. And we say, in short, that is the territory that we are in here. I should mention, because it's not referenced in the case, that this court also considered, in a very different context, VAT scheme in relation to demonstrator cars, abuse of EU law in commissioners for Her Majesty Revenue and Customs and Pendragon. That's 2015 UK Supreme Court 37. And again, Lord Sumption described in that case the abuse of law in its simplest forms, confines the exercise of legal rights to the purpose for which they exist, and precludes their use for collateral purposes. And we say this is only partly a question of the rights of Vedanta. It is also very much a question of the duties on the English court to, as the Advocate General Tesaru in the Tatri, which we refer to, indicated, it will be incumbent upon the court seized to ensure that any abuse is thwarted. And that is also echoed in Dicey and Morris, 12033 MS 6902. So finally, and sixthly, looking at the clock, the sixth point that I would make is this. We cannot know, because the EU court has yet to determine this, the answers to the reference issues which we have posed at paragraph 387, MS 218 of our case. Namely, first, whether as a matter of EU law, national courts are permitted or obliged to take action to guard against misuse of Article 4 for a collateral purpose in the circumstances of these types of cases. And secondly, what is the requisite test for this? Is it one of the principal reasons that the judge held? Does it have to be the sole object, etc.? But even if that test is satisfied, what, if any, restrictions does the regulation impose on the power of the court to grant relief to an EU defendant in those circumstances to prevent the jurisdiction rule being misused? And in particular, is it all remedies available under national law? Or are some still precluded, such as forum non-conveniens or otherwise, by the effect of the regulation in those types of circumstances. We certainly don't know whether a precautionary approach can be adopted by the court if it suspects abuse, if in fact there is no real objective prejudice to the parties, if a precautionary approach is taken and claims are stayed because an alternative forum, for example, being available. So those are the questions that we have sought to set out. In 30 seconds, I would just like to make one point in relation to the two cases the judge relied upon. That was Freeport and CDC, the two European cases. The core point was there, they were dealing with Article 6.1, now Article 8.1 rather than Article 4. But the point that we were seeking to make from those two cases was that in 2008, in relation to Freeport, the European Court appeared to close the door to the use of the principles of abuse of EU law in relation to the regulation. And Freeport is AB 11, that's MS 6377. But by 2015, when the European Court revisited the issue in CDC, and that is MS 6303, the court adopted effectively the elegant solution put forward by the Advocate General in that case, which was to seek to construe Freeport as saying not that the court couldn't take into account abuse of EU law in appropriate cases, but that it didn't have a duty to do so in every case if there was, on the other hand, evidence of such misuse for a collateral purpose, then the court could take that into account, and he looked at the test in terms of distorting the true purpose of that rule of jurisdiction. But Article 8.1, my final point, Article 8.1 is very different to Article 4, and not in the way in which the judge suggested. The judge suggested that somehow the test must be at least as high or higher under Article 8.4 as opposed to 8.1. 8.1 is dealing with a situation where the court and member state is able to bring other cases from other member states into one court to consolidate. And so that is dealing with the balancing of rights as between EU domiciled defendants, at least one or more of whom have to give up their entitlement otherwise to be sued in their own jurisdictions. It's dealing with a very different situation to Article 4. And that, I think, brings me to the end of the time. We've also dealt with Brexit very briefly.
Well, you're about 2 minutes over your time.
Everything we
but
can
that'll
say.
Come
I
off
do
your
apologise.
reply time.
Thank you.
Thank you very much
Thank you.
indeed. Well, Mr. Hammer.
My lady, my lords, I've got rather modest aims for the short amount of time that's left available this afternoon.
It's usually the best you can do.
Can I try and do two things? One, just to give you a thematic overview of a response by way of observation, and then, if time permits, just to hand up a roadmap so you can see where I'm intending to go tomorrow. Can I make three opening observations? Firstly, we say this is a legally unremarkable case. It should be resolved by straightforward application of uncomplicated principles of procedural and substantive law governing long-established jurisdictional rules. It should also be resolved by the recognition of the very limited role, we say with great respect, of an appellate court in reviewing first instance decisions applying those rules. There is nothing, we submit, remotely revolutionary or novel in the legal basis upon which these claims are brought. The most it may be said is that the facts are unusual, concerning as they do pollution of a waterway in a foreign country. But it would be wrong to allied unusual facts with legal novelty. And as we examine each ground of appeal, we will invite the court to reject the appellant's attempt to refashion well-established rules on the basis of subjective characterization of the facts of the claim. Indeed, we say even the assertion of factual novelty needs to be treated with some caution. There is, in truth, we say, nothing radically different in these claims to many other cases. The mere fact the claim concerns a legal wrong overseas and concerns foreign parties is an unremarkable feature of modern-day litigation. Indeed, this appeal turns on and is all about the application of rules whose very purpose is to cater for transnational litigation, at least in element. Equally, there's no novelty in our courts dealing with large group claims. As Mr. Gibson has referred to, CPR Part 19 deals with large group claims. And our courts have successfully managed claims that are far larger than this one. There is also nothing unusual about transnational environmental litigation, reflected not least in the fact that the applicable EU choice of law, a framework, Rome II, provides an express exception to the general rule of which law applies in a tort claim. In environmental cases, granting claimants in environmental cases a wider choice of applicable law under Article 7 than is the norm. See also recitals 24 to 25 of the regulation that explain the rationale behind that, not least the principle that the polluter pays. So there's nothing unusual per se in transnational environmental litigation. And tomorrow...
Isn't that usually about the pollution originating in one state and the damage felt in another state, which is genuinely transnational, whereas that's not this case?
My lady's right, and I don't push the point beyond to observe that within the choice of law framework, within the EU framework, transnational environmental litigation is A, envisaged, and B, it's given a particular stress and import, unsurprising in today's age it may be thought, by the wider choice of law rules available. I'm also going to seek to show to the court tomorrow that there is nothing at all remarkable about the tort claim against the parent company. For over 20 years, domestic courts of the highest standing have thought it an unremarkable proposition, dependent of course upon the facts, that a parent company can at least arguably owe obligations in tort to those harmed by the activities of a subsidiary company, not through violence in any sense to the principles of corporate separateness, but through the application of straightforward principles of tortious liability. Rules of procedure and substantive law of tort have always, by necessity, we submit, moved with the times. It's an unremarkable feature of the globalised world that decisions can be made in London that can have a direct effect on people at the other end of the planet. And it is equally unremarkable, we submit, that procedural rules and substantive tort law can provide for accountability and remedies in that globalised world. To paraphrase, if I may, Lord Diplock in the Aberdeen Deva, one of the great features of the common law is that it develops so as to enable justice to be done in the changing circumstances in which it falls to be applied. My second observation, if I may, flows from that first proposition about the straightforward nature of the case, and it's about context. There is, of course, an important emerging international soft law framework that my Lord Wilson referred to this morning that addresses the liability of multinational corporations, set out in the helpful, we respectfully submit, intervention of the ICJ and the Core Coalition. But whilst we are very grateful for those submissions, and we think they are important, my arguments are in no sense dependent upon that international law framework. It provides a context, but to be clear, my case is that the appeal turns on the application of trite principles of EU and English law, albeit we say it's unsurprising that they correspond with wider international principles. That is not to say that the human rights context of these claims are irrelevant. They are, we submit, relevant, but their relevance is primarily as to how some of the well-established tests should be applied in this particular claim, rather than defining what those tests are or what they should be. They are particularly relevant when we turn to issues of access to justice, and also, if the court considers it necessary, contrary to submissions I'll make tomorrow, to ask whether it would be fair, just and reasonable to oppose a duty on common law. My lady, my lords, the facts of the case and the seriousness of the allegations are self-evident from the pleadings and the evidence, and I will obviously not labour any of them, save to make one point, if I may, at the outset, that I shall not repeat. And that's about a particular impact of environmental damage on this class of claimants. Large-scale environmental damage is, of course, a matter of grave concern wherever it occurs and whoever is impacted. But the position is, we submit, a fortiori here, where it intersects with extreme poverty. That is because the claimants are not simply dependent upon the waterway for vital aspects of their life, as described in the pleadings, but because their levels of destitution are such that it is almost impossible for them to take steps to ameliorate the impact. The state cannot effectively intervene. They themselves plainly cannot afford alternative sources, including alternative sources of clean water, nor are there alternative livelihoods. And that is why, in the context of those who are living in extreme poverty, damage to the environment cuts to the very heart of human rights. Now, having said that, can I be plain that the claimants do not seek the sympathy of the court, and in respect of many of the tests that are before the court, their plight is irrelevant. But if nothing else, it will serve to underline my submissions in respect of the importance of access to justice. My third and final observation is also about access to justice. It's about the need, recognised by this court in VTB, to ensure that claims are not priced out of litigation at the very first hurdle by permitting preliminary interlocutory applications to serve out, becoming vehicles by which richer parties can outsource poorer parties. There is no doubt that the claimants here are the poorer party. They are some of the poorest inhabitants of the planet and proceed only because there are legal advisors willing to act in this country, willing to act under a CFA, and they've managed to retain one of the very few firms willing to act on that basis with the resources to even contemplate the cost risk of fighting an interlocutory application of this nature, costing tens of thousands of pounds in order to meet the evidence served by the defendant and stretching over months and into years. We have now spent 3.5 years not focusing on remedies for the spills, but on an interlocutory process in which, although my learned friend's position is much more modest before this court, has included parties having to spend hours and thousands of pounds arguing, for example, that Owusu was wrong and the English court should not be bound by it. Arguing, for example, that Chancellor was a case that had to be limited to the particular facts of an asbestos industry. So we submit that the appropriate response is for judicial control to be imposed by reiterating the court's message in VTB, namely the straightforward nature of the relevant tests under both EU law and the CPR, rejecting the invitation to engage in mini-trials of the merits of claims, and also by the reaffirmation of the limited role of the appellate courts. And we say the court can do that, safe in the knowledge that the various threshold tests under the CPR already provide more than adequate safeguard to protect both domiciled and non-domiciled potential defendants from unmeritorious or abusive claims, or claims that simply have no business being tried before the English courts. And even if, contrary all to that I say, it was thought that there were greater protections that were required in domestic law under the rules for service out, we would respectfully submit that in any event that would be a task best left for the Rules Committee, who can examine it against the full horizon rather than on an ad hoc basis seen through the particular facts of this case. My lady, those are my opening observations. Can I briefly hand up a roadmap for tomorrow so that the court can see where I'm intending to go subject to the court's preference?
Very helpful. Thank you.
While this is being handed out, can I just raise, there's one case not contained in our printed case that I am going to refer to tomorrow. I wouldn't be so presumptuous to suggest it for overnight reading, but it's a very recent decision of the New Zealand Court of Appeal just before Christmas in the case of Hardy, which is dealing with parent company liability, and it considers all the cases that are in the written case. You'll find it in the supplementary bundle 6. I'm afraid there are 3 bundles of 6. It's supplementary 6, tab 48, MS 1598. It's the case of Hardy. The lead judgment given by the now newly appointed Chief Justice of New Zealand.
I think it's March that she takes up office.
That's right, my lady, yes. I think it came 2 days after the announcement. If the court has the roadmap, you'll see that I'm intending to address you on 8 topics. most of which I'm intending, subject to the court's preference, to deal with at quite a clip. I'm going to spend a bit of time, if I may, looking at the common law claim because it's been such a feature of my learned friend's case. But apart from that, I will deal with it. And I'm going to seek to, if I may...
Which is the most serious issue in the case, in a sense.
It is.
In a sense.
In a sense. But what I'm going to do, and I hope it's helpful, is cut it up into 4 ways. Firstly, I'm going to look at the test of real issue and the invitation that somehow it should be changed and there should be an extra degree of scrutiny in a case such as this. Then, if I may, just isolate the law first on common law, insofar as it actually survives my learned friend's concession that he accepts paragraph 36 of Lord Justice Sale's judgment in Unilever. So look at the law, look at the statutory context, and then, hopefully with a light touch, just look at the evidence on a summary judgment as opposed to legal analysis. But I'll, of course, be guided by what's going to be most assistance to the court.
Thank you very much, Mr. Milady. Very well. We will now adjourn and look forward to hearing from you at 10:30 tomorrow morning.